Hey, everybody, good morning. Thank you all for joining us for our Advocacy Cafe. We're really excited to have this specific topic as it is a topic that has come up quite frequently. So Tom Prettyman is coming on to talk to us about tenant rights and obligations, domestic violence and housing, repairs, the eviction process, also about subsidized housing, COVID pandemic related housing issues. So if you have any questions, please go ahead and put them in the chat. And as mentioned, as always, we are going live on Facebook just in case somebody might come across this information and might find it beneficial to share with your organizations or widely within your community. So if you are joining us from Facebook or on Facebook, please place your questions in the comment box and I will go ahead and keep an eye out on that. This session is also being recorded. So just in case, if you all have misinformation or would like to look back, you are more than welcome to. We will have it up on our YouTube channel within a couple of days, and I will be sending you an email with the recording link, a survey to obtain your certificate for participating today and your attendance. Again, if you have any questions, please let us know. This is the perfect time to ask your questions and how to support survivors that might have a lease or are trying to break the lease. Tom is here with us to support you all. So if you have any questions, please put it in the chat. And with that being said, I will now turn it over to your facilitator today from New Mexico Legal Aid, Tom Prettyman. Thank you so much for being here with us.
Hi, can you hear me?
Yeah, you're good to go.
Okay, so if you see any questions, feel free to just ask them. You can interrupt me. I'm from New Mexico Legal Aid, and New Mexico Legal Aid, as a lot of you know, gives free legal services to low-income New Mexicans. We are statewide. We have offices all over the state. Um, our intake is by telephone or online, mostly, although we do a lot of outreach events and sometimes meet clients there. We also have referral relationships with some of you folks. New Mexico Legal Aid handles civil cases, and that includes things like consumer issues, benefits issues, like someone's Social Security is being taken away, or someone was denied Medicaid, or someone was denied unemployment. We handle those things. We also do domestic violence representation, representing survivors in DV order of protection hearings and related family law cases. And we handle housing issues. And that's the department I'm in. I wanted to talk to you about landlord-tenant law in New Mexico. The disclaimer, this is not legal advice. If you want legal advice, speak directly with your lawyer or give me a call and maybe I can give your clients legal advice. The first thing I want to talk about is the importance of housing, and you folks probably know this, but housing is one of the key components of keeping our clients safe and healthy. Without a roof over their heads, they're more prone to violence. Job loss often results from people being homeless. More police interventions result from people being homeless. People who lose their homes, their kids stop going to school. They often lose their benefits because they don't respond to a letter that was sent by Human Services to their former address. They can't make their doctor's appointments because their doctor is near their home, and when they get evicted, they're staying with grandma over on the west side and they can't get to their doctor. So a lot of things result from people being evicted. So it's a lot more than just, oh, they're changing addresses. So at New Mexico Legal Aid, if we can, and we're representing somebody, we try to keep them from losing their homes. There's a lot of laws applicable to New Mexico residential tenancies. It's the main law is called the Uniform Owner Resident Relations Act, and that's our state landlord tenant law. But there's a lot of other federal, state, and local laws that apply, including the Violence Against Women Act, which has protections for DV survivors who live in government subsidized housing, and the Fair Housing Act, which is a powerful tool we can use for our clients who are disabled, which is a large proportion of our clients. The Uniform Owner Resident Relations Act, or some people call it UORA, is the acronym. All evictions must start with a written notice from the landlord, a pre-termination notice. The landlord has to say in writing what the tenant did wrong, often has to give the tenant an opportunity to fix the problem in a certain amount of time, or to move out in a certain amount of time. The landlord cannot go to court to evict a tenant before giving this notice. And there's four kinds of notices under state law. The first and the most common one is rent. The most common reason a tenant has a falling out with her landlord is she's not paying rent. If a landlord wants to enforce this non-payment of rent, she has to give a written 3 days notice, and it has a right to cure. So the notice says you owe $700 in rent. You have 3 days to pay this $700. And if the tenant pays in the 3 days, she has an absolute right to stay. It ends. But if she doesn't pay in the 3 days, on the fourth day, the landlord can go to court. On the fourth day, the landlord doesn't even have to accept the money anymore. They can just go to court. Um, um, the the next most common kind of notice is the notice of material noncompliance, and this is most non-rent violations. That's noise, disturbances, unauthorized pets or occupants, damage to the unit, trash on the porch, smoking in the unit if it's a non-smoking unit, use of marijuana, misdemeanor use of marijuana in the unit. I guess there is no misdemeanor use anymore because marijuana is legalized. But things like that, those usual things that might happen between a landlord and a tenant. The notice has to be given 30 days after the occurrence, or 30 days after the landlord learns about it, or the landlord waives the issue. It's not a violation anymore. The notice has to give the tenant 7 days to fix the problem. And if the tenant fixes the problem in 7 days, she has an absolute right to stay. But if she doesn't fix on the eighth day, the landlord can go to court. Or if the tenant gets two of these 7 day notices in a 6 month period, the landlord doesn't have to give the tenant a right to fix the problem in 7 days. On the second notice, the landlord just says, get out in 7 days. And if the tenant's not out in 7 days, on the eighth day, the landlord can go to court. Another kind of violation, not as frequent, is called the substantial violation. This is the really serious violations that have to do with drugs, assault, weapons, burglary, robbery, intentional damage of property in excess of $1,000. So if there's one of these kinds of violations alleged, the landlord gives the tenant 3 days to get out. It's a 3 day notice without a right to cure. So that should say without, not with. And I'll fix that before I share this. Let's fix it now. Um, Now, substantial violations arise a lot in the DV context, and sometimes material noncompliance. Victim and abuser have a fight in the unit, and the abuser does something. The abuser breaks property, wakes up the neighbors, breaks a window, maybe uses a weapon, maybe hurts the victim, and the landlord's response might be to evict the victim or evict both of them if the abuser is a co-tenant. And the law says it's not a substantial violation if the tenant didn't do it and she didn't consent to it. So the tenant survivor certainly didn't consent to getting beat up, didn't consent to the abuser breaking the window or hurting her or using a weapon. So That's really important. And the final kind of notice that a landlord will give is the end of term notice. It's generally a 30-day notice. If it's a month-to-month lease, the landlord can end it for any reason or no reason, um, just by giving 30 days notice. Um, if it's a week-to-week lease, which is sometimes the case in extended stay motels, it only has to be a 7-day notice. If it's the end of the lease, most written leases are for 1 year, and they say after the year's up, it automatically becomes a month-to-month lease unless either side gives one of these 30 days notices. It has to be given 30 days before the next rent due date. Most people's rent is due on the 1st with a grace period till the 3rd or the 5th. So if the rent's due on the 1st, the notice has to be given 30 days before the 1st. So that's generally the 1st of the month, or in a 31-day month, that might be the 2nd of the month. They don't have to give a reason. In New Mexico, you can end the lease for no reason at all. There's exceptions. You can't do it for a discriminatory reason, say because of the person's race or religion or gender. And you can't do it in most kinds of subsidized housing that is project based. And that would be like HUD multifamily projects, public housing, USDA rural housing, and tax credit housing, low income housing tax credit called LIHTC to a lot of people. Does anybody have any questions right now? Um, the notice has to be given before the landlord files. If the last day to fix the problem, to pay the rent, to get out falls on a weekend or a holiday, the tenant gets till the end of the next business day. So if the last day fell on September 4th and Labor Day is Monday, September 5th, and it's say a 7-day notice of trash on the porch, then the tenant will have till a minute before midnight on Tuesday, the 6th, to clear up the trash and stay. If the landlord files early, which often happens, the judge is supposed to dismiss the case and tell the landlord, sorry, you filed too early. It's dismissed without prejudice, which means no decisions made. You have to go and refile, landlord. A lot of judges won't dismiss that unless the tenant has a lawyer. When a landlord goes to court, that landlord is restricted to what they said in the notice. If the notice is about rent and they attach that rent notice to the complaint to evict the tenant, they can't start talking about trash or violence or things like that. It's restricted to what they put in the notice. If the landlord gave a notice about trash, he can't go to court and ask the judge to evict the tenant for unauthorized occupant living with the tenant. Whatever the landlord is going to rely on in court, they have to give a notice first. Most issues between landlords and tenants arise from rent. Luckily, for the last year and a half or so, we've had the Emergency Rent Assistance Program in New Mexico. This is federal money. The tenants can access this program through their website, nmhomefund.org. It used to be renthelpnm.org. Now it's a new website. This will pay past due rent plus 3 months future. I think they go back 12 months and they'll pay the 3 months future rent. They'll also pay utilities. They have combined the Mortgage Finance Authority's Homeowner Assistance Program into this program. It's no longer under Mortgage Finance Authority. It's under the ERAP program, where they will help people who are not eligible for traditional mortgage relief that is available in foreclosure cases catch up on their homes. So an example is people buying mobile homes. Or people who are buying homes through seller financed arrangements, where, for example, buyer signs a contract to buy a piece of real estate. It's not a mortgage. They just pay the seller uh, monthly payments of principal, interest, insurance, and taxes. And the contract says after 15, 20, 30 years, when the last payment is made, the seller has to give the deed to the buyer. This program will help buyers catch up on that. The application's online. Um, for tenants living in Bernalillo County outside the Albuquerque city limits or in Doña Ana County, it's a separate program run by those counties. And I believe the nmhomefund.org website has a link where tenants residing in those counties can access those programs. Again, for Bernalillo County, it's only outside Albuquerque city limits. In Albuquerque, the tenants access the regular nmhomefund.org funding. How does a landlord evict somebody? Well, they can't do it through self-help. They have to use the court process. The court process for evicting someone is called a petition for restitution. Restitution is New Mexico's euphemism for eviction. It's the same thing. The landlord files a written complaint in court. In New Mexico, they can either go through magistrate or metropolitan court, or they can go through district court. But almost all landlords use metropolitan court in Bernalillo County and magistrate court outside of Bernalillo County because those courts are cheaper to use, they're quicker, they're easier to use for people that don't have lawyers, and they're generally very pro landlord. The written petition is filed in Bernalillo County at the Bernalillo County Courthouse at 4th and Lomas. The filing fee, I believe, is $77 and another $40 to have the sheriff serve the petition on the tenant. The sheriff serves a summons. The summons notifies the tenant of the hearing and how to attend. The hearing is set in 7 to 10 days usually. It could be a little farther out, but the law says the landlord's supposed to get a hearing in 7 to 10 days. Most courts these days are holding hearings through Zoom or Google Meet for people attending by video, or phone for people who can't access video. Bernalillo County is 99.9% remote. There are some counties that are holding in-person hearings, but if you have some kind of reason why you can't attend in person, then you can ask them to use the Zoom or Google Meet or the phone. If the tenant wins, the tenant gets to stay. If the tenant loses the hearing, the judge orders the tenant to move in 3 to 7 days. So the order will say, move out on X date, and that date is supposed to be 3 to 7 days out. During COVID, some judges have been giving tenants longer. If the tenant doesn't move out by the deadline, the landlord takes a piece of paper called a writ of restitution, and it's a court order that the sheriff evict the tenant. In Bernalillo County, if the tenant's not out, say on the 7th day, and the landlord takes the writ to the sheriff on the 8th day, it usually takes the sheriff another week to get out there to evict the tenant because the sheriff's really busy. In other counties, the sheriff goes out on the day that the landlord asks, so it can be quicker. And the sheriff just gives the tenant a few minutes to get out. Doesn't give them a lot of time to collect stuff. And we tell our clients who are facing eviction by a sheriff, pack your bags, all your important papers, your meds, your family artifacts, clothes, toiletries, kids' clothes and diapers and things like that. Pack them and put them by the door because the sheriff's going to give you minutes to get out. And then the tenant has 3 days to go back and get the rest of their stuff. Tenants in New Mexico have a right to appeal their eviction. The appeal has to be filed the earlier of the eviction date or 15 days. And if the tenant pays the post-judgment rent on time as the appeal goes on, they get to stay in the unit. They don't have to pay the money that was at issue in the judgment, but they have to pay the rent going forward. And they get to stay in the unit while the appeals judge, which is the district court usually, decides the appeal. Are you sure you don't have any questions? My throat's getting dry here. No one?
No
Okay.
questions.
Okay. Um, Ask a silly question. It might not be that silly. Okay, so a lot of people have heard about the CARES Act, and the CARES Act did a lot of stuff. It's from back in March 2020, and one of the things it did was it put a short-term moratorium on evictions from subsidized properties, and that moratorium ended July 2020 when we were still in the middle of the pandemic. But one provision survived, and um, first of all, to talk about the CARES Act, we need to know what properties it covered. They defined something called covered properties, and they defined it as all properties that are subject to VAWA housing protections, and that's subsidized housing, tax credit housing, Section 8, public housing, housing for people with AIDS, home housing, continuum of care vouchers, rural housing from the USDA. All these are covered by VAWA, so they're automatically covered by the CARES Act. And then they added in properties with federally backed mortgages, and that's VA loans, HUD loans, Fannie Mae, Freddie Mac. There might be some more. So all these properties are covered by the CARES Act. And what the CARES Act has left is um, they have to, properties that are going to evict for non-payment of rent, instead of providing the 3-day eviction notice required under state law, these properties have to provide 30 days notice before going to court for non-payment. So that's a little more breathing room for tenants. It's not clear that the CARES Act would give tenants 30 days to pay off the debt, but they still might have only those 3 days to pay, but the landlord still must wait 30 days to file. And a lot of landlords are ignoring this. And generally, they get away with it unless the tenant has a lawyer. New Mexico Supreme Court also imposed a stay on certain evictions, and that is also dating back to March 2020. And what it did is if a landlord went to court for just non-payment, and in court the tenant convinced the judge that they had an inability to pay the rent, it didn't even have to be COVID related, they just couldn't pay the rent, then the judge was supposed to say, landlord, you win. I'm going to give the judgment for you. One day you'll be able to evict this tenant, but today's not that day. This eviction is stayed until further order of the Supreme Court. Well, the Supreme Court lifted the stay. They issued an order. They issued orders in January and March of this year, phasing in a lifting of the stay county by county. By now, all the counties have had the stay lifted. So all these tenants who didn't pay their rent but had an inability to pay the rent, and the trial judges stayed the eviction. Now the landlords have the ability to go to court and evict the tenant if money's still owed. But this order issued by the Supreme Court says that the landlord has to include a resource information sheet with the summons, and that gives information about the ERAP program and about legal services. When these parties go to court, the court tells the parties about the ERAP program and asks if they want to participate in rent assistance or mediation. It's called eviction diversion. And if both sides agree, the judge says, okay, we're going to postpone the case for 30 days while you guys talk and while the ERAP program looks at your application. And if one of the sides does not agree to do the eviction diversion, the judge holds a trial, and if the tenant loses, the judge issues the writ of restitution. So that's what's going on with the Supreme Court stay. The important thing here is the tenant needs to show up for court, because the landlord might choose to let the tenant participate in ERAP, and it might save the tenancy. In Bernalillo County, they generally have on the Zoom call a representative from ERAP to give information about the status of applications, help parties who have not yet applied for ERAP get the application started. They're really working hard to get as much ERAP money out there to save tenancies, pay landlords, and keep people housed. The landlord-tenant law addresses repairs. The important thing here to know is give written notice. The tenant needs to put the request for repairs in writing. A letter's fine, an email's fine, a work order is fine as long as the tenant can get a copy to prove they did it. They can just take a picture with their phone, I guess. A text is fine too, except a lot of our clients don't have the ability to save texts for long periods of time, or they change phones, they lose that phone number, get a new phone, and they lost their text, so they can't prove that they requested repairs. The landlord's required to make the repair in 7 days. If the repair isn't completed in 7 days, the tenant has the right to abate rent, which is what we call withholding rent. If the tenant remains living there, they can abate 1/3 of the daily rent back to the date of the notice until the repair is completed. In subsidized property, that 1/3 of the total is based on the total rent, not just the tenant's portion. So if it's Section 8 and the tenant pays $100, but the total rent is $1,000 because the housing authority pays the other 900, the tenant can abate 1/3 of $1,000 per day, which is more than the tenant's share, which means the tenant doesn't pay anything. If the repair issue makes the unit uninhabitable and the tenant temporarily moves out, they can withhold 100% of the rent date back to the date of the notice. Judges in Bernalillo County generally restrict abatement to health and safety issues. So some issues are it's questionable whether it's health or safety or not, and maybe the tenant needs to speak with a lawyer about whether they should abate or not. Other landlord-tenant issues addressed by the UORA landlord-tenant law are the landlord's right of entry. Some landlords abuse the right of entry. They don't give proper written notice before entering. The notice has to be in writing with a purpose of the visit, reasonable time frame of entry, and 24 hours ahead of time. If this kind of notice isn't given, that's not allowed. Or some tenants are given proper notice, but they don't let the landlord in, which could be a violation. The law addresses illegal lockouts. Landlords are not allowed to make threats or shut off the utility or change or remove the locks to try to evict someone without going to court. It imposes penalties for that kind of behavior. The law addresses retaliation. Landlords are not supposed to end the lease with a no-cause termination notice within 6 months after a tenant engages in some kind of protected activity, like complaining to HUD about a fair housing violation, testifying on behalf of another tenant, issuing a request for repairs, things like that. There are special laws for mobile home park owners. People own their trailers but rent a space in a mobile home park. There's special rules for fire and casualty. There's the law addresses damage deposits. Landlords are supposed to give an itemized statement of deductions from the deposit within 30 days after the tenant moves out. If they don't give the itemized statement within 30 days, sometimes they waive the right to keep the deposit. Domestic violence is a important topic in housing law. The Violence Against Women Act contains housing protections. As we discussed before with the CARES Act, it applies to federally subsidized housing. It does not apply to programs that don't have any subsidy or programs with only state or local dollars. In most cases, VAWA bars eviction or termination of subsidy for the victim of an incident that is directly related to domestic violence. Directly related is always the magic question. HUD has said a short-term failure to pay rent due to domestic violence might be directly related to domestic violence. A broken window, broken by the abuser, certainly seems directly related to domestic violence. Sometimes abusers move in with their victims and they're not on the lease, and the victim gets in trouble because the abuser is found to be living there. And that could be directly related to domestic violence if the survivor doesn't want to confront the abuser and have them kicked out. We also run into problems where um, the cycle of domestic violence makes it seem like the abuser's not doing anything about, I'm sorry, the victim's not doing anything about the abuser. And while the landlord might be sympathetic the first time that the tenant is a victim of domestic violence, when it keeps happening over and over and over again, the landlord gets frustrated and wants to take action. And we get into the complication of survivors unable to break ties with the abuser because of financial ties, because they share kids, because maybe they still love them. And at what point do they become liable for the abuser's conduct? An important thing under VAWA is every single termination notice, whether it be non-payment of rent, 7-day notice of material non-compliance, substantial violation notice, has to be accompanied by VAWA's notice of occupancy rights and a HUD form that allows the tenant to claim that the alleged violation is directly related to domestic violence. The landlord does not have to know that the tenant's even going to raise domestic violence. They just have to attach these notices with every single termination form, because a lot of tenants don't know that it's not, they're not supposed to be evicted if they're the victim. VAWA also contains provisions on transfer. So if a victim needs to flee the abuser and move to a different unit operated by the landlord, then VAWA provides for that. It provides for confidentiality, where the victim's information about what's happened to her has to be kept separate from the other tenant files, and only certain people are allowed to see it, not the general staff. For tenants who are not protected by VAWA because they live in unsubsidized housing or they live in state subsidized housing, there are limited protections under the State Landlord Tenant Act, which bars eviction of the victim for a DV incident if the tenant gets a DV order of protection. If the tenant does not get a DV order protection, then the judge has discretion, meaning it's up to the judge whether to evict the victim. Twice now, there's been bills introduced in the legislature to make the state landlord-tenant law protections for DV victims stronger. It's twice proposed by Senator Cedillo Lopez. It hasn't passed yet. Maybe they'll take another stab at it. One thing that it wants to provide for is allowing an express right of DV victims to break the lease without penalty if necessary due to DV. And that could be because the abuser knows where they live and they need to change addresses, or it could be because of anxiety or PTSD because that's where the abuse happened, and for their health they need to get out to another place, so they're not traumatized by continuing to live there. So hopefully that'll come around again and it will pass. Any questions?
There is one in the chat where it's asking ERAP is only for rent-related evictions, not for other violations.
There doesn't have to be an eviction. I would encourage any tenant to apply for ERAP as soon as they know that they're falling behind on rent and they can't afford to pay it, because the landlord, if the tenant is otherwise a good tenant, the landlord just wants their money. They want to be able to pay their bills. And if the money's going to get paid, they'll say, I'll hold off on the eviction because it looks like this tenant's doing everything they can to get it paid. So it's not, doesn't necessarily have to be an eviction. the money is not going to cure a non-money issue. So if the tenant's being evicted because they had too many parties or they caused property damage or things like that, the money's not going to cure the issue. And so that's not going to be a successful way to resolve it. However, some landlords might be willing to overlook non-rent violations if the tenant it becomes current. Maybe some landlords say, well, I was fine with a tenant being messy and not taking out her trash immediately before because her rent was paid. But now that her rent is not paid, I'm done. So maybe it could be resolved. Um, Now, as far as the eviction diversion program in court, maybe that's the question they're asking. The eviction diversion program is where the judge asks the parties if they want to participate in the eviction diversion. That is, you're correct. That is generally only for rent evictions. The eviction diversion program, they have an office and a staff, and they try to contact every tenant and every landlord before court and say, hey, we've got this beautiful program. You want to participate? They say they're getting in touch with about 70% of litigants. So that's good. Um, and they're trying to head off the issues before it even gets to the judge. Um, a big issue right now in New Mexico is while under state law you can evict somebody at the end of the lease without a reason, in most site-based subsidized programs, you have to have a reason. Um, Public housing, tax credit, HUD multifamily projects, these USDA rural development housing, these kinds of housing say that the tenant gets to live there forever as long as the tenant doesn't screw up, doesn't it pays the rent and doesn't commit lease violations, and as long as the landlord's in the program. So a landlord can't just give a no cause termination notice. They should go through the 7-day notice of material noncompliance or the 3-day notice of non-payment of rent. And if a landlord files based on a 30-day no cause eviction, the judge is supposed to deny the complaint and not evict the tenant. However, a lot of judges don't know this rule. It's a clear-cut rule. They just don't know it. Or they don't know that the project is subsidized. They don't know the unsubsidized apartment complex from the subsidized apartment complex unless the landlord or the tenant tells the judge. The tenant often doesn't know or is too scared to say anything or doesn't know that it matters, or they don't even show up to court. And the landlord keeps their mouth shut about that stuff because they don't want the judge to know. With a lawyer, tenants are usually able to avoid these no-cause evictions if they're in this kind of housing.
Tom, I have another question.
Yeah.
Can a tenant be evicted if they temporarily leave their apartment due to domestic violence to enter a shelter for safety if they are current on their payments? How long can someone stay out of the apartment before eviction is considered abandonment?
The law defines abandonment as gone for more than 7 days without notice to the landlord with rent being owed. So I think a tenant in that situation, if she's paying rent, it's not abandonment. However, I think she needs to notify the landlord anyway for a lot of reasons. One, the landlord might just want to know if she's still living there. Did she skip out? What's going on? Second, the landlord might want to keep an eye out because the abuser might be coming by, or other folks might be coming by to see what they can do illegal in an empty apartment, steal things, who knows. Um, Sometimes victims can't pay the rent for various reasons. Let's say the abuser was the sole breadwinner, or the abuser took all the money out of the bank account, or what else? I don't know. So the tenant could be subject to a claim of abandonment. So in that case, the tenant needs to notify the landlord, perhaps in writing, "Hi, I had to flee because of domestic violence. I will call you as soon as possible, um, and I will pay you as soon as possible." Subsidized housing. Subsidized housing is a whole another topic. However, some important things to know about subsidized housing is public housing and Section 8. Any notice from the Public Housing Authority, the PHA, has to be accompanied by information to the tenant that they have a right to what's called an informal hearing and a deadline to request this informal hearing. So the informal hearing is an administrative hearing where the tenant gets to go in and listen to the housing authority's reasons for wanting to terminate their subsidy, and then present evidence or argument why this is wrong and why the tenant should keep their subsidy. The tenant has a right to a lawyer, though not a right to a free lawyer. So their only lawyer is generally going to be New Mexico Legal Aid if they contact us and we have a lawyer available for them. They have a right to look at their file. And they importantly have a right to continue their subsidy until the informal hearing is completed. The hearing officer is supposed to be impartial, though they often aren't. The decision of the hearing officer has to be in writing. So if you have a client who has gotten a notice from a public housing agency that their Section 8 or public housing is going to be terminated, they should always, always, always request a hearing, because one, they might get the housing authority to change its mind, or might get a hearing officer to say this termination is no good. And second, at the very least, they get their rent paid. They get to stay in the program until the hearing process is completed. There's a lot of different public housing programs. Each one's different. They have different notice periods. Some require a 10-day notice for this kind of violation. Some require a different kind of notice, a 14-day notice. They have these requirements called specificity requirements, where the landlord has to be specific about time, date, and facts of when something occurred or didn't occur. They have special service requirements. They have requirements that the notice has to be delivered to the tenant in a certain way. They have this informal hearing requirement we talked about. And in other kinds of subsidized housing, there's often a right for the tenant to meet with the owner to discuss the termination. Special laws apply to subsidized housing, including VAWA and the CARES Act, and Section 504, which is a special anti-discrimination statute. Subsidized housing generally requires cause to evict someone, though a private landlord taking a voucher from a Section 8 or other voucher tenant does not need to have a reason to evict someone at the end of the term. And sometimes, if the issue is only about rent, judges will allow a tenant who is behind on rent an opportunity to pay off the debt so they can keep their housing. Fair housing laws apply to landlord-tenant relationships. The most important law is the Fair Housing Act, which is like the ADA for housing. It generally prohibits discrimination against tenants on the basis of religion, gender, national origin, race, and disability. They also require an owner to reasonably accommodate the tenant with a disability, so the tenant can have the same enjoyment of the unit as non-disabled tenants. Examples of reasonable accommodations: maybe the tenant needs to change their rent due date to coincide with benefits. Maybe they get the benefits in the middle of the month, but the rent's due on the first of the month, and so they make a written reasonable accommodation request. Please accommodate my disability by allowing me to pay rent by the 16th. They can get an extra bedroom, perhaps, for a live-in caregiver or for medical equipment as a reasonable accommodation for the disabilities. The Fair Housing Act can require landlords to accept service animals and companion animals. Service animals are those that are trained to do a task for the tenant. Companion animals are just any pet that a tenant needs to get by. Another common example of a reasonable accommodation is an ask to the landlord to disregard a violation that's due to the tenant's disability. Let's say the tenant's experiencing difficulties with their meds and they changed case managers or therapists, and all this is not great for their mental health, and they act up. They either cause a disturbance, um, they chew out the landlord, they threaten the landlord, or maybe even they commit some kind of violence, and the tenant might be able to ask that be disregarded as a reasonable accommodation for the tenant's disability. They generally would have to show some kind of light at the end of the tunnel. I changed my meds, doctor's adjusting my meds, I'm settled in with a new therapist. This is unlikely to happen again. The owner can take the tenant at their word, but they have a disability and that they have a disability related need for the accommodation, or the owner is allowed to request a letter from the tenant's doctor to verify a non-obvious disability and to confirm that there's a nexus between the disability and the requested accommodation. Many sources would say that the landlord's not allowed to just ignore the request for accommodation. They can grant it. Maybe they can deny it, but if they're going to deny it, they have to first engage in some kind of interactive process with the tenant where they say, well, we don't think this is reasonable, but maybe we can come to some kind of middle ground. Albuquerque, you might have heard, has a new source of income ordinance. It, I believe, becomes effective next week, the 26th, but I might be wrong. It amends Albuquerque Human Rights Ordinance to bar discrimination in the sale or rental of housing based on source of income discrimination. Source of income includes wages, benefits, and vouchers. So the landlord cannot refuse to accept vouchers. If the tenant's otherwise eligible and you count the voucher, the rent paid by the voucher, as part of the tenant's income and they qualify, um, then the landlord has to take them. They can't refuse to accept vouchers. They can't impose stricter qualification requirements on voucher tenants than non-voucher tenants. Or, for example, tenants with vouchers have to make 4 times the monthly rent to live there, but tenants without vouchers only have to make 2 times the monthly rent. They can't impose a higher security deposit on tenants based on their source of income. It also requires it also only requires the landlord to wait 5 days. That's 5 business days for the housing authority to inspect the unit after the landlord and tenant request approval of the unit. If the public housing authority cannot inspect the unit in 5 days, then the landlord can move on to another tenant. There are penalties under the city code for violating the city code, including the source of income ordinance. The penalties are up to $500 fine and or up to 90 days in jail. Now, some landlords are already required to accept vouchers under federal law, and that's tax credit landlords. Okay, that's the end. Does anybody have any questions? You either ask about stuff I talked about or different stuff.
I do have, I'll keep an eye out on the chat, but I do have a couple of questions to why we reached out to you all to do this training for us. And wanted to see, you might have already answered it with the presentation, but we have 2 scenarios that we were kind of looking for, some education on. So there was a survivor. We had a survivor find an apartment, but unfortunately, with the offender stalking the survivor, she was obviously in fear and did not want to break the lease. How can she be protected, or how can the landlord protect the survivor and also not evict the survivor due to the restraining order, and also not decide to kick her out due to police officer presence or possible altercation? So she wants to keep the apartment. He knows where she lives. He's stalking her. How can she be protected to remain there?
Well, she should file for a DV order of protection. Sometimes that's difficult because maybe the stalker doesn't have a fixed address or is hard to serve. So if you can't serve them with the summons or serve them with the order, um, that's not a perfect solution. Sometimes the order's in place, it's effective, but when the stalker shows up and violates the order, by the time the police get there, the stalker, who's kind of savvy, is gone. The tenant could move if the landlord has another unit available, different side of the building, or a totally different building would be better, then maybe that's a good solution. She doesn't have to move far. She remains housed, and the stalker, at least for the time being, doesn't know where she is. That could be required if the housing provider is subsidized. If they're unsubsidized, there's no law requiring that, but the landlord might want to do it just because it's in everybody's interest that this violent person not find the survivor.
Can the landlord evict the survivor due to like police presence, possible, altercations, him coming over, just arise?
Under state law, the landlord would have to give a notice, a written notice, and then proceed to court. And if the tenant has a DV order of protection in place against the abuser, and this is all related to that incident, I would ask her. I would hope that she contacted New Mexico Legal Aid because we'd be interested in the case. But hopefully, the judge would say, no, this is an incident that's a result of domestic violence. She's not getting evicted. The landlord could perhaps get a criminal trespass order, which is an order that says to the stalker, "Don't go on my property." And if the stalker violates, the police are entitled to arrest that person. Under federal law, there are transfer provisions. So it would be required of a covered property under VAWA to make efforts to transfer the tenant. And in fact, public housing agencies and for example, are required to have a transfer plan in place. What is their plan for transferring DV victims who request transfers because of DV? The law says that the landlord cannot evict the tenant for an incident that is directly related to DV. There is an exception. VAWA does allow the landlord to evict the victim if she poses a direct threat. But the direct threat definition, which would be a direct threat arising from the stalker coming around, is a really high bar. So that doesn't come into play much. I believe it's imminent threat of or imminent probability of substantial physical harm or something like that. VAWA does not specifically say a tenant can terminate their lease early without penalty, although I would read at VAWA as inferring that that's allowed. Often DV victims are faced with disabilities, PTSD, anxiety, and physical disabilities too. Often as a result of the DV, not always, but the DV certainly exacerbates it. And they need to get out, not just for their safety, but for their disability. The continued presence in the unit exacerbates their PTSD. And the Fair Housing Act might give them a right to a reasonable accommodation for their disabilities in the form of leaving the lease early without penalty. So if it were my client, I might write a letter to the landlord saying she's got to flee violence. She's moving out and she's asking for an early termination of the lease, effective whatever date, without penalty. So I said, if the landlord said no, I'm gonna charge you termination fees and more rent, et cetera, et cetera. They might be violating the Fair Housing Act.
Thank you. And earlier you mentioned about, being a direct threat. So direct threat to whom? To the landlord, to the people around her, to...
I don't have the law in front of me, but I believe it's neighbors and employees,
Okay.
the people on the property. So I guess, you could imagine a dangerous abuser has a firearm and threatens to shoot up the place. Maybe that's a direct threat, if it's a credible threat.
Thank you. I have one more scenario and then we have another question in the chat.
Okay.
Thank you for answering that, by the way. I know that there's not just the simple, answer to these questions. There's a lot of different ways that we can go about things.
Uh-huh.
So the second scenario is we had an underage survivor. She was 17 and the offender has the lease under his name. And he abused her, obviously. He has agreed to leave the location, but the lease cannot be transferred to her due to her not being 18. Can a lease be transferred to someone else if the victim is underage and the offender is willing to move?
I don't know. VAWA for covered properties has provisions that says if you evict the abuser, you have to give a certain amount of time for the remaining household members to qualify as leaseholders. So as long as they're income qualified, they pass the usual background checks, etc., then they should be given a chance to take over the subsidized tenancy. And I'm not really sure how it works with minors. I've never encountered that. Maybe the minor has to be emancipated. Maybe the minor's parent can sign the lease. I just don't know.
Okay.
If this is still an issue, they should contact New Mexico Legal Aid, and maybe we can answer it.
And what about the opposite? Say that they're both, not underage and, the offender is unwilling to move. What can the survivor do if that lease is under her name?
Maybe if the landlord's cooperative, the landlord might be willing to evict just the abuser. That's called bifurcating the lease. Or if the landlord is not cooperative and takes both of them to court, says, I don't care. It's just a domestic. You people are just too much trouble. I don't care who did what. You're both out of here. And the victim chooses to challenge that in court. The judge is sometimes required or sometimes just has discretion, meaning it's up to them, to evict the abuser and let the survivor stay. Under federal law, it's a little more rigorous. If the eviction is due to directly related, is the term, to domestic violence, the judge is not allowed to evict the victim, evicts the abuser. But another way is the victim goes to family court and does and asks for a DV, order of protection, and the court is authorized to evict the abuser from the home, and generally a eviction judge is required to abide by that.
Okay.
Under federal law, if they're subject to VAWA says the landlord has to abide by a DV order of protection. And if the DV order of protection, if the DV commissioner has already decided who the abuser is and told the abuser, get out of the home, don't return, then if the landlord's covered by VAWA, they have to obey that. Under state law, it might not be so clear.
Thank you. I appreciate those answers. So back to the chat, we do have a question about the SOI ordinance. After the SOI ordinance starts, what should we do if we speak with the landlord who immediately says that they do not want to work with vouchers? Is there a handout? Is there a handout or something that we could use to educate the landlord about the ordinance?
Um, I feel like there is a handout, and I'll find it and I'll send it to you, Terry, and you can send it to the group, and also send you a copy of the presentation for the group. But I believe it's the city human rights officer who fields complaints. And my understanding of the way the human rights officer is, she tries to get people to do the right thing. That's their way of doing things. However, they are authorized to take people to court, and there's fines and jail time potentially. I don't know if that'll happen much. I don't expect that landlords will say we don't take vouchers after they get educated. They're going to say, well, we turned you down because of your background check, and we turned you down because you don't make enough money. Um, and the test there is, do they apply that standard to all their tenants, voucher and non-vouchers? They can't, for example, make voucher tenants say voucher tenants have to make 10 times the rent versus non-voucher tenants have to make 3 times the rent. But those things are hard to prove because we don't have access to the landlord's mind, and we don't even have access to their files without going to court. So we'll see how this works.
Thank you. Hopefully that answered your question. And we have one more. We work with a lot of households with past evictions, some which are due to domestic violence, but they were unaware at the time of the eviction what steps to take with their landlord and didn't report the domestic violence to the landlord. Is there any way to go back to try and remove this from their record or remove the fees, such as they fled for DV and didn't want to report it to the landlord and ended up with an eviction and fees? So they left and weren't paying.
I don't know. It might be that it's not too late to reopen the case. So if it's been 30 days or less, there's a good chance they could get the judge to revisit. If it's been a year or less, it's a tougher call. But there's a rule that says you can go back and challenge a judgment within a year. You generally have to show some kind of compelling thing that happened. There was misrepresentation by the plaintiff. You didn't get properly served with the summons. There was some kind of big mistake made. Maybe this would qualify. After a year, it gets much tougher. But one thing that VAWA does do in subsidized and tax credit housing is it also deals with admissions. It's not just evictions, it's admissions. So the survivor goes to apply for, say, public housing, and the public housing provider says, we're not taking you. You were evicted last year from this such and such a residency, and we don't take people who have evictions on their record from the past 2 years. And then the applicant says, wait a minute, that's because I just broke the lease. I fled because I was being pursued by an abuser. The VAWA says the covered property that's denying an admission has to attach a notice of occupancy rights in a HUD certification form to the written denial. And that gives an opportunity to the tenant or the hopeful tenant to say, wait a minute, this is DV. They have different options in any situation on how to prove DV, whether they're being evicted or denied admission. It can be the HUD certification form where they write out what happened. It can be a DV order protection. It can be a police report. It can be a signed certification by a DV services provider, some other things too. But the tenant can give this kind of information. And we've had success here where tenants were denied their applications to public housing was denied because of past rental housing issues. And we were able to show that the tenant fled the residence, moved to Colorado because of DV. The the husband or boyfriend or whoever remained in the unit and then incurred the indebtedness. And therefore, this was directly related to DV, and the housing authority must disregard this as a disqualifying factor under VAWA. And that doesn't deal with the judgment, but it does deal with her getting new housing, and it worked. The housing authority said, "Okay, that's the law. We're fine with that." But you have to raise that, and it helps to have a lawyer, of course.
Okay, it looks like those are all the questions, and thank you for your response to those questions.
You're welcome.
Any other questions?
Hey Terry, so if anybody has any questions, email me. That's the best way to get in touch with me. If I don't respond, it wasn't intentional. Just bug me. Email me again. Squeaky wheel gets the grease. Thanks. Have a great day.
Sounds good. Thank you. Bye, everybody.